If you've just been notified that the U.S. Patent and Trademark Office has issued an office action on your trademark application, and you've looked at this scary looking document that's chock full of legalese and you're freaking out right now, I want you to take a breath. Don't panic. Office actions are a very common part of the trademark application process, and here's what you need to know about them. Hey friends, welcome back to my YouTube channel. I'm Faith Mitton, an attorney on a mission to simplify brand protection for business owners. On this channel, you'll find tons of easy to understand content that is geared toward helping you to get a better sense for how to use trademarks to protect yourself, as well as how to stay on the right side of the law. Speaking of which, office actions do help you stay on the right side of the law because they document the reasons why a USPTO examining attorney believes that your trademark application does not qualify for approval. Okay, so what is an office action? Let's back up for a second and put some context on this thing. Trademark applications are not the type of legal filing that get automatically approved. LLC filings tend to get approved this way, so if you filed your LLC online and got an instant approval, don't expect the same thing to happen with your trademark application.
Nope.
But leaving LLC world and coming back into trademark world, trademark applications can only be approved if they satisfy all the relevant legal requirements. And there are many legal requirements that apply to a trademark application. Because of this, the USPTO has a staff of attorneys whose only job is to review the hundreds, if not thousands, of trademark applications that the agency receives every single day to check whether these applications satisfy all the legal requirements. The sheer number of trademark applications that get filed, combined with the fact that each application has to be reviewed by an actual person, not an algorithm, result in the trademark application process taking a really long time. But when a USPTO examining attorney does finally get assigned to your application and reviews your application, and they discover that there are issues preventing your application from being approved, they are legally obligated to let you know what those issues are to give you a chance to correct them. And that's what an office action is. A legal notification in writing from the USPTO explaining why your trademark has been rejected and what legal requirements that it has failed to satisfy. That's also why office actions are written in funky legalese, because they are always written by attorneys. So, what does an office action look like, and what types of issues can it address? First, the office action will identify who it is being addressed to. If the trademark was filed by a person or a company that did not have attorney representation, the office action will be addressed to that person or company. However, if the person or company did have an attorney representing them in filing the trademark, the office action will be addressed to the attorney. Then the office action will tell you whether it is final or non-final, and those things mean exactly what you think they mean. A non-final office action is one the USPTO sends you to address an issue for the first time. A final office action is one the USPTO sends you after you have made a response to the non-final office action, but they are still unsatisfied with your application for whatever reason. Regardless of whether you have received a non-final office action or a final office action, you will still have an opportunity to respond and address and really fix whatever issues the USPTO has identified. The next part of the office action will explain to you the deadline to respond. Right now, as of this recording, the USPTO is giving trademark applicants 3 months to respond to a trademark office action, but you can get an additional 3 months if you pay them a small fee. You need to be careful about monitoring this deadline and responding to the office action before the deadline hits, because if you do not respond on time, your trademark application will become abandoned, and an abandoned trademark application cannot be approved. There is a short window after abandonment, during which you can pay a small fee to the USPTO to revive your application. So if you've missed the deadline, there may still be a path forward for you, but it's just best to not miss that deadline and file on time. Under the information about the deadline is the most important part of the office action, a summary of the issues that the USPTO examining attorney has flagged on your application. You want to make sure that you pay close attention to this summary because it is essentially a checklist for all the issues that you have to respond to when you make your response. And if you miss an issue, your response is incomplete, which can result in some negative consequences. There are two types of issues that a USPTO examining attorney will flag in an office action. These are procedural issues and substantive issues. A single office action can address just procedural issues, just substantive issues, or a combination of the two. But let's look at each of them, procedural issues and substantive issues, separately so you get a better understanding for what they are. Procedural issues are technical errors with an application that can usually be fixed with a quick corrective filing. Let's look at 3 examples of very common procedural issues. Number 1, classification. There are 45 different classes that you can apply to register a trademark in, and each trademark application must be filed in at least one class. These classes are broad categories of various activity, and they are not based on your industry. Instead, they are based on groupings of different products and services. So you have to correctly match your class to the products and services that you are describing in your application. If you don't, you will get an office action. If you have selected the wrong class or your description of products and services includes more classes than you have paid for, you can usually quickly address that with a corrective filing to reclassify your application. Number 2, the description. I just mentioned describing your products and services in the application. This description is a necessary part of the application process because, like I said before, there are only 45 classes that you can register a trademark in, and there are more than 45 ways of doing business or categorizing products and services. So those classes are huge and cover a really broad range of different things. So it isn't enough just to list a class. You have to specify the products and services that you are seeking protection for with this trademark. This description has to be in the right technical format and it must match the class. If your description isn't in the right format or there are some other issues with it, the USPTO examining attorney usually will give you a suggestion for how to reword the description in the office action itself. Number 3, specimens. A really common procedural issue in office actions has to do with the specimen that is filed with the application. A specimen is proof for how you are using your trademark. In the US, unlike other countries, you must actively be using a trademark in order to get trademark rights. So trademark applications in the US cannot be approved unless there is public use of the trademark. Website screenshots are most commonly used as specimens, but there are other different things that you can use as specimens as well, depending on what you do and how you perform your services or how you provide your products. But trademark applicants tend to trip up when they file a specimen that does not show the trademark exactly as it was applied for. And I say exactly because it must match. Any little variation can make the USPTO reject your specimen. Another reason why specimens get rejected is because the specimen doesn't match the class that the application was filed in, because there are different types of specimens that are appropriate for products versus services. No matter the reason for your specimen being rejected, the USPTO office action will explain why it is insufficient and give you direction about how to file a proper specimen. Switching gears, let's look at substantive issues in trademark office actions. These are the polar opposite of procedural issues because they cannot be fixed with a quick corrective filing. Instead, they will usually require a well-written, properly formatted, persuasive legal argument that includes all the relevant evidence. Now let's take a look at 3 common substantive issues that appear in trademark office actions. Number 1, mere descriptiveness. Descriptive trademarks are weak trademarks, meaning that they can only get limited protection. These types of trademarks tell people about a feature, purpose, use, function, ingredient, characteristic, or something else, about your products and services in a very obvious way. Descriptive trademarks get hit with office actions because the USPTO has to avoid granting exclusive rights to a particular company or brand over terms that other companies might have a legitimate need to use to describe their products and services. But the USPTO isn't always right about a trademark being descriptive. If you are able to convince the USPTO examining attorney that your trademark is not descriptive, then they will withdraw the office action. But if your arguments are unsuccessful, then you still have a path forward to getting your trademark approved, except this time it will have to be approved on the supplemental register, not the principal register. The principal register grants exclusive trademark rights to the brand owners whose registrations appear there. Trademarks on the supplemental register do not have the benefit of exclusivity, so they're a little less desirable than being on the principal register. The second substantive issue that is really common to see in these kinds of substantive office actions is likelihood of confusion. Trademarks are all about protecting a business's brand identity. So the USPTO will not approve a trademark application if it is confusingly similar to a pending application or one that has already been approved, which exists on either the principal register or the supplemental register. The reason for this is to prevent situations where people could mistake one brand for another when they both have basically the same protections, and that can end up harming both the businesses and the individual people who are confused about which business is which. To beat a likelihood of confusion refusal, you'll have to convince the trademark examining attorney that your trademark can be distinguished from whatever trademarks they have cited against yours. If it's more than one, you have to respond and deal with the likelihood of confusion with each trademark. There are many ways to do this, but the right strategy to use will vary depending on the specific facts of your situation. There is no one-size-fits-all approach to responding to these likelihood of confusion refusals. What might work for one application will not work for another, and so that's why it's useful to have legal assistance to prepare these kinds of responses. The last really common issue that you'll see in a substantive office action is a failure to function refusal. In order for something to function as a trademark legally, it has to help people identify a specific company or person as the source of certain products and services. But there are many types of situations where something that has been chosen as a trademark doesn't actually function this way. A good example of this is when someone tries to trademark a common phrase that's used by people everywhere, such as, "Hello, how are you?" Or if they try to trademark something that's simply informational, for example, all natural ingredients on food packaging. If you get a failure to function refusal, the office action will not be withdrawn unless you can show with persuasive evidence that people have come to associate your trademark over time with your specific business instead of just random sayings or general concepts that anyone can use. You may also be able to overcome a failure to function refusal if you can show that the USPTO's examining attorney isn't right about this particular phrase or word or concept being as broadly used as they think it is. Regardless of the type of office action that you get and the types of different issues that it might address, remember that an office action is a temporary rejection of your application. If you don't respond to the office action or are unsuccessful in getting the USPTO to withdraw it, then the rejection will become permanent. If that happens, you may be able to appeal the rejection to a higher authority known as the Trademark Trial and Appeal Board to continue fighting for your trademark. But be warned, the Trademark Trial and Appeal Board backs up USPTO examining attorneys more than 90% of the time. So if you get an office action, your best bet to getting it withdrawn and moving your application forward is to convince the examining attorney to see things your way or to correct whatever issues that are technical that the examining attorney has flagged for you. A trademark attorney who has had lots of experience handling trademark office actions should be able to help you evaluate your office action to see whether there is a path forward for your application and to figure out the right strategy to file your response. With that, I'll wrap up this chat about trademark office actions, and I hope it was helpful for you. If you enjoyed this video, please give it a thumbs up and be sure to subscribe for more trademark content and to turn on notifications so that you don't miss when I drop a new video. And I love to hear from folks who watch my stuff, so if you have questions or thoughts, please feel free to drop them in the comments. Thanks for watching. I'll see you in the next video.